Amendment 6, Right to a Speedy Trial. Hello and welcome back. Today we will be discussing Amendment 6, the right to a speedy trial. And this amendment, when it was written in 1791, states as is: in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusations, to be confronted with the witness against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So, what does this all mean? The right to a speedy trial and public trial, or jury trial. In this case, Amendments 6 and 7 work together to solidify what a jury trial is and should be. In a criminal case, the government prosecutes or charges a defendant with a violation of criminal law and begins proceedings, such as bail hearings, arraignments, and trials, to prove that charge beyond a reasonable doubt. All criminal trials are tried by the state. So currently, I am personally awaiting the trial of a guy who burglarized my house. It isn't Svidron versus Scumbag, it's Pennsylvania versus Scumbag. Because the state is the only one that can prosecute. So it's never an individual versus another individual. Now, making sure the person accused of a crime has their case heard or presented in front of a court, a person is guaranteed what is known as habeas corpus, which is a Latin term for putting the body in front of the court. This was widely violated by our 16th president, Abraham Lincoln, during the Civil War, who put people in jail or prison without regard to those hearings. This is illegal, and the ACLU, or the American Civil Liberties Union, would jump all over it today. The state must also prove beyond a reasonable doubt that a person is guilty. Next semester, we'll be looking at different court cases and talk about the effects of reasonable doubt. For the time being, think of it as putting doubt in someone's mind. Did you really see that person, or someone looked identical to that suspect? The Sixth Amendment provides many protections and rights to a person accused of a crime. One right is to have his or her case heard by an impartial jury. Independent people from the surrounding community who are willing to decide the case based only on the evidence presented. In some cases where there has been a significant amount of news coverage, the Supreme Court has ruled that jury members may be picked from another location in order to ensure that the jurors are impartial. When choosing a jury, both prosecutor and defense attorneys may object to certain people being included. Some of these objections, which are called challenges, are for cause, in which the potential juror has said or done something that shows he or she may not act fairly. Others are preemptory. No real reason can be given or is given, but one side does not want to have that person serve. Lawyers cannot use preemptory challenges to keep people off a jury because of race or gender. The closest I came to serving on a jury happened when both lawyers liked my background during a case in which a delivery driver to steel mills got cancer and died from the floating asbestos in those mills. One of the lawyers liked the fact that my father worked in a steel mill, so he thought maybe that I would side with the steel mills because my father worked there his whole life. And at the other point, the other lawyer would have normally objected, except he liked the fact that my aunt died from the cancer that one gets from that certain asbestos that's in the air. So either way, I would have, as I told these lawyers, I would hear the case and then make a decision. I wouldn't just jump all over just because my father worked in a steel mill or just because my aunt died from that same cancer. Um, Needless to say, I sat there for 8 hours. We got home. We got sent home because they reached a settlement before the case ever went to trial, and that happens a lot. Now, the right to a speedy trial is considered one of the most important in the Constitution. Without it, criminal defendants could be held indefinitely under a cloud of unproven criminal accusations. The right to a speedy trial also is crucial to assuring that a criminal defendant receives a fair trial. If too much time elapses between the alleged crime and the trial, witnesses may die or leave the area, their memories may fade, and physical evidence may be lost. Like the right to a speedy trial, the right to a public trial serves the interests of both criminal defendants and the public. Defendants are protected from secret proceedings that might encourage abuse of the justice system, and the public is kept informed about how the justice system works. Like most constitutional protections, however, the right to a public trial is not absolute. A criminal defendant may voluntarily give up or waive his or her right to a public proceeding, or the judge may limit public access in certain circumstances. For example, a judge might order a closed hearing to prevent intimidation of a witness or to keep order in their courtroom. Pennsylvania is one of the few states that does not allow televised proceedings. The Sixth Amendment right to be informed of the nature and cause of the accusation is another protection meant to ensure that the accused receives a fair trial. A speedy public trial that is heard by an impartial jury is meaningless if a defendant is left in the dark about exactly the crime for which he or she is charged. The so called confrontation clause prevents prosecutors from relying on witnesses' out of court statements to make their case. Rather, it requires that prosecutors put their witnesses on the stand under oath. As the U.S. Supreme Court explained in its 1970 opinion, California versus Green, the defendant's ability to confront a hostile witness in person puts pressure on the witness to tell the truth, allow the defendant's counsel to cross examine that witness, which may reveal him or her to be unreliable, and gives the jury an up close view of the witness so that they can decide for themselves if a witness is believable. There are exceptions to the confrontation clause, of course. If a knowledgeable witness is unavailable at the time of a trial, for example, a previous statement will be allowed into evidence so long as the witness made it under conditions that were similar to those at trial. For example, if the statement was made under oath. Defendants also may be prevented from confronting witnesses against them when the well being of the witness is an issue. For example, child witnesses may be allowed to testify in the judge's chambers rather than in open court. The Sixth Amendment guarantees a criminal defendant the right to have an attorney defend him or her at trial. That right is not dependent on the defendant's ability to pay an attorney. If a defendant cannot afford a lawyer, the government is required to provide one. The right to counsel is more than just the right to have an attorney physically present at a criminal proceeding. The assistance provided by the attorney must be effective. This does not mean that the defendant has a right to an attorney who will win his or her case. A defendant can receive effective assistance of counsel and still be convicted and sent to jail. This right to an attorney, regardless of ability to pay, is all thanks to one Clarence Gideon, who attempted to defend himself on charges and failed because he didn't know the law. We will be talking about him soon. However, if an attorney's performance is not up to reasonable standards for the profession, or if the attorney's ability to put on a full defense is hindered by the prosecutor's misconduct, then the defendant may be able to challenge his or her conviction. This provision does not guarantee the right to an attorney in most civil cases. And since the Sixth and Seventh Amendment are tied together, we are going to go over the Seventh Amendment, which is the right to a jury trial. In suits in common law, where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re examined in any court of the United States than according to the rules of the common law. The Seventh Amendment extends the right to a jury trial to federal civil cases if the value in question is over $75,000. It's no longer $20, which, by the way, in 1791 would have been a lot of money. The five most heard types of civil cases in which jury trials are requested include contract disputes, property disputes, torts, class actions, and complaints against the city. In civil cases, the person bringing the lawsuit is known as a plaintiff. They seek money or monetary damages or a court order preventing the person from being sued, who is known as the defendant, from engaging in certain conduct. To win, the plaintiff must prove his or her case by a preponderance of the evidence, that is, by over 50% of the proof. Now, I mentioned tort, and tort's very interesting, and we're going to talk about torts later. But a tort is a wrongful act that usually leads to injury and a big payday for certain people. The two examples that come to mind include the woman who ordered a coffee from McDonald's drive-through. She pulled over, she placed the coffee between her knees, and she removed the lid to add cream and sugar, and the coffee tipped out of the cup and burned her private property. She sued McDonald's and won $3 million, and this was in 1992. So $3 million in 1992 was a lot of money. It still is today, actually. The issue wasn't the negligence on her part. Again, you can sue people because you're stupid. Keep that in mind. But the case stemmed around the fact that the coffee was so hot. Now, McDonald's doesn't brew their coffee to be molten fire anymore, and there are descriptions on the side of the cup that say hot with steam arrows. Um, McDonald's had to right their wrong, so they had to not only change their advertising, they had to change their cup, but they had to change the temperature of their coffee. The second case involved a woman from Mount Pleasant who was leaving Walmart while carrying her bags, and one of those grocery bags ripped open. A bottle of ketchup fell out, hit her on the toe. She was wearing open-toed sandals, and it caused damage to her toe. It split her toenail, and I think it broke her toe. She ended up suing because Walmart had put too many items in the bag, making it too heavy. Now, of course, she's suing for medical bills and lost work and lost wages and so on. Um, so now Walmart has to rate each bag. They can only put so many items in each bag. Interestingly enough, here the woman's husband also sued Walmart, saying that the injury to his wife impeded his cuddle time. The court threw that case out. When does common sense prevail in those cases? Well, when I was a kid, I was running with a Tinker toy and I fell and I impaled the Tinker toy through the roof of my mouth. I had to have it surgically removed. We didn't sue Tinker toys. It was my fault. In fact, to this day, I don't run with Tinker toys or sharp objects. Although the Seventh Amendment itself says that it is limited to suits at common law, meaning cases that triggered the right to a jury under English law, the amendment has been found to apply in lawsuits that are similar to the old common law cases. For example, the right to a jury trial applies to cases brought under federal statutes that prohibit race or gender discrimination in housing or employment. We'll talk about those cases later on. But more importantly, the Seventh Amendment guarantees the right to a jury trial only in federal court, not in state court. And once the federal court rules on one of those civil cases, it can never be heard again. Have a great day, Mount Pleasant.